All right, guys, welcome back for Section 9 of Intro to Criminal Justice. Are you all excited? Here is our funny internet picture of the section. I love dogs. They're so cute. Especially little dogs in little suits with a little tie like that. That's just cute, man. Like, come on. That's just cute. All right, so we're going to try and get through the entirety of Section 9 in one video, which means we're going to have to go pretty fast. So, a trial. Obviously, we're talking about criminal trials here, not civil trials. But which court you go to is going to depend on the jurisdiction of each court. Okay, and that jurisdiction is not just based on geography. So we've talked about this in previous sections, where jurisdiction, most people, when they hear that word, they think geography. But there's also which specific law was broken and what level of crime are we talking about. Is it a misdemeanor? Is it a felony? Is it a capital case? What are we talking about? Each one of those things will have an impact on which court you actually show up to for your criminal trial. Now, that lowest level of court, remember at the federal level, we call it the Magistrate Court. Depending on what state and city and county you're in, they might be called something else in the state system. But they're all courts of limited jurisdiction. Okay, those are the lowest level of courts. Usually they're there for like misdemeanors, traffic tickets, stuff like that. You know, very, very low level stuff. If you are not, if the maximum punishment for the crime does not include jail or prison time, you are not entitled to a lawyer. You can have one if you want, but usually people don't have it. Like, I went to court once for a traffic ticket, and I didn't have a lawyer. And, you know, if I'd have been like, I'm too poor to afford a lawyer, they would have been like, yeah, it's a traffic ticket. You don't get a free lawyer. They're usually very, very short trials. You know, it's just you walk up, explain your side of the story. The prosecutor walks up, explains their side of the story. And then usually the judge is the one that makes a decision, right? There is no jury. At these low level courts, there is no jury. There is no people deciding whether you're guilty or not guilty. It's only the judge. And similarly, there is no record, right? So I know we've all seen on like movies and television and stuff at the felony trial, and the lawyers are judge and doing all the things, and there's the jury and everything. There's also that person sitting in the corner with a little typewriter looking thing, like pushing the keys and keeping a record of everything that's said in that trial. That's called the stenographer. And courts of limited jurisdiction don't have that. There is no record of exactly what's said. Obviously they keep a record of like the outcome of the case and stuff, but they do not have a record of exactly who said what, who objected, who, all those things. So this means if you appeal a trial that you went to in a court of limited jurisdiction, you have to start all over again. You can't just point to the trial record of the original trial and be like, look here where the judge says this and this, I'm going to appeal based on that. You can't do that because there is no record. Double jeopardy. Double jeopardy is a vastly misunderstood concept, okay? Just because you do a similar thing does not make it double jeopardy. It has to be the exact same incident that you are going on trial for. Okay? It's not just a similar thing. It's not, it has to be the exact same thing. Now, there are certain cases in which double jeopardy does not apply. If the single act that you commit violates both federal law and state law, you can get tried at each level. So the federal government can try you, and let's say you get found not guilty, the state can then try you, because those are two completely separate levels of government. Having one federal trial and one state trial does not violate your double jeopardy rights. Similarly, if I committed a crime within two states, let's say I kidnapped somebody in Texas, drove across the border to Oklahoma, and then murdered them. I can be tried for that crime in both Texas and Oklahoma, and that's not going to violate my double jeopardy rights. Similarly, let's say I commit one crime with a whole bunch of victims. I can get tried for each one of those victims separately. Okay? And the federal government actually used this this theory, or this kind of method to get around double jeopardy with Timothy Mcveigh. Now, Timothy Mcveigh, he was the Oklahoma City bomber back in the mid-90s. He blew up a court building in Oklahoma City. Hold on. He committed this blatant act of terrorism in Oklahoma City. So the federal government decided that it really, really, really wanted to give this guy the death penalty. But what if they tried him, and instead of getting the death penalty, the jury or the judge or whoever decided to give him life in prison instead? Well, the prosecutors weren't having any of that. They really wanted the death penalty. So what they did was, they didn't try him for all of his 80, I think it was 85 victims. They only tried him for the death of one victim. And their plan was, if they didn't get the death penalty for that crime, that one victim, they had a second chance. They would try him for the death of a second victim. And if they didn't get the death penalty there, they would get a third chance. And they could theoretically go all the way up to 85 chances, assuming it was 85, I think it was 85 victims. But they had that number of chances to try to get the death penalty for him. And every time they failed, they could just restart the trial with a new victim and a new jury and see if they could get the death penalty then. Now, they ended up getting the death penalty on their first try, so they didn't have to end up using this, but that was kind of the theory and the thing that the prosecutor was going for. So, bail. We talked about bail a little bit in a previous section. There are very disturbing class differences with bail. Okay? So, if you're rich and you get, assigned some amount of bail, obviously you can afford to just pay that bail. If you're middle class, upper poor level, and you get, bail is set, you can afford a bail bondsman, which is still good because you get out of prison, but now you're out that 10%. The rich people got their money back when they came to trial because they paid their bail directly. The upper, lower class and the middle class, they're just out 10% of the bail. They can't get that back. If you're very poor, you can't even afford the bail bondsman, so you just have to sit in jail until your trial, which can be months, which means you've lost your job, you're probably getting evicted from your house, you lose your car, right? So bail is one of those things where there's a movement trying to address that class difference and figure out a way where we can make sure that the bail system doesn't disparately impact the poor people and lower middle class people, and the people who are just, the people who are least able to afford bail are the ones who are most punished by the system. Prosecutors have a very large amount of discretion. Prosecutors are able to do almost anything they want. I mean, there are laws that constrain some of their choices and such, but they are allowed to do a lot within those very loose limits. Okay, so for instance, at the arraignment, the prosecution is the one that gets to come in and say, okay, we're going to charge them with 1 count of this and 5 counts of that and 8 counts of this other thing and all these things. And they get to decide without any outside influence, or very, very little outside influence, exactly what people are going to be charged with. That is a huge amount of discretion, okay? Now, there is some outside influence, such as the grand jury, or, if they have to go through a preliminary hearing, but those are mostly kind of a pro forma thing. And the prosecutor gets entire discretion on what gets brought to them, right? So there's lots of different ways that the prosecutor can influence the thing. One of the biggest is that prosecutors do plea bargaining. Okay, 90% plus, depending on your jurisdiction, but 90% plus of all criminal trials are dealt with through a plea bargain, not an actual trial. So prior to trial, the prosecutor just comes up and says, hey, look, I'm charging you with 10 counts of assault. If you plead guilty to 3 of them, I'll drop the other 7. That way, it saves me time and energy. It saves you time. You're only getting convicted of 3 counts instead of 10 counts. How about it? Helps out both of us. And the vast majority of the time, those plea deals are accepted. When prosecutors brag about their, I remember there was one back in Texas, way back in the day, a prosecutor bragged about his 96% conviction record. So I looked it up, and he had a 94% plea bargain rate. So really, he won 2 out of 6 of the cases that he went to trial, was what he was saying. I mean, it's ridiculous. But there are 2 kinds of plea bargains. Okay, there's charge bargaining and there's sentence bargaining. So plea bargaining is the umbrella. Under that is charge bargaining and sentence bargaining. Now, the prosecutor has basically unlimited discretion on charge bargaining. And that was like the example I gave before, where he says, I was going to charge you with 10 counts of this, but I'll only charge you with 3. Or, I have you for first-degree murder, but you can plead guilty to second-degree murder. That is a change in charge, right? And the prosecutor has discretion over that. The other kind of plea bargain is a sentence bargain, where he says, look, I've got you for first-degree murder, plead guilty, and I'll make sure you only get 25 years, right? Or I've got you for capital murder, plead guilty, and I'll make sure you get life in prison instead of the death penalty, okay? That's not a change in charge, that's a change in sentence. And for that, the prosecutor needs the judge's approval. The judge gets to step in and kind of say, well, all right, that's a good plea bargain, or no, that's a bad plea bargain, whatever. But the prosecutor needs the judge's approval for a sentence bargain. The prosecutor has basically unlimited discretion for a charge bargain. Make sense? Good. So, a statute of limitations is a very important concept. What it basically says is that depending on the crime, depending on the jurisdiction, depending on a lot of things, there is usually some amount of time between when the crime occurred and when somebody is charged. Okay? So if it's a lower level crime, there will be a shorter statute of limitations. So if it's assault, the statute of limitations might only be a couple years. If it's sexual assault or deadly assault or something, the statute of limitations gets longer. There is no statute of limitations for murder. Murder is one of the few crimes where there is no statute of limitations. Doesn't matter how long it's been since the crime, you can always charge somebody with it. But for lower level stuff, car theft, burglary, stuff like that, if it's been too long, that person can just get away with it. Okay? They've completely, they could, walk up to you and say, yeah, I committed that burglary 15 years ago. Statute of limitations is passed. Suck it. There's nothing you can do about it, right? So it is very important to know how long that statute of limitations is if you're interested. If you're a victim of a crime and it's been a while, you might want to look up and see whether somebody could even theoretically be charged with that crime in your jurisdiction. And it's different whether you're talking about federal or state or local or any, all those different jurisdictions have different statute of limitations for crimes. Okay? One of the amendments guarantees a speedy trial. Okay? Problem is, what exactly constitutes a speedy trial? Does that mean if I'm charged with some crime, I have to be tried within a month, 6 months, a year? Does that mean the start of the trial has to be there, or the end of the trial, or the sentence, or what? I mean, when does the clock start, and when does the clock stop? Right? Does it start the day I'm arrested? Does it start the day I'm charged? Does it start, does it end when I'm brought to trial? Does it end when I'm finished the trial? I mean, this is kind of a gray area, okay? So different jurisdictions, different levels of government have put different clocks on it. Sometimes they say it's got to be 100 days. Sometimes they say it's got to be 6 months. Sometimes it's different. And it's also different depending on who causes the delay, right? So if the prosecution has to delay the trial for some reason, the clock keeps running. If the defense has to delay the trial, they put in some motion that delays how long it takes before the trial can come, then the clock stops. So any delay caused by the defense does not contribute towards that person's speedy trial right. But in essence, when it comes right down to it, what constitutes a speedy trial and what constitutes an unspeedy trial depends on the judge. If you can convince a judge that, however long, this amount of time between this and this violated your rights to a speedy trial, then that's up to the judge to decide, okay? When you're in court, there are tons of different rules of evidence, okay? Everything from the Daubert standard, which says that any scientific technique has to be generally accepted by the scientific community at large, to the best evidence rule, which says that you can only use a copy of a document if the original is unavailable. There's all these different rules of evidence, and you have to follow those. You have to make sure that evidence is carefully collected. You have to make sure that it's carefully stored. You have to make sure that it's carefully analyzed, and then you have to make sure that you're presenting it in court kind of the right way. And all those rules of evidence, hopefully you will learn about those in like an evidence and procedure class. If your university requires you to learn those. I don't know if I'm ever going to put that class up on this YouTube channel. Who knows? Maybe. Contempt of court. Contempt of court is a very, very interesting charge. Essentially, here, contempt of court, the judge has complete discretion. If you upset the judge, if you refuse to answer a question, if you refuse to follow the judge's orders, if you do something that upsets the judge basically gets to say, I'm holding you in contempt of court. The bailiff is going to take you and you are going to sit in a jail cell until I decide you can come out. A lot of times that means, you're going to sit in a jail cell until you agree to answer my question. You're going to sit in a jail cell for a day because you did something obnoxious in court. You insulted me during the trial or whatever. There's very little oversight from outside of just the judge. And essentially, with a little bit of exception, if you refuse to answer the judge's question, they can make you sit in jail for as long as they want. Right? It's a very... be nice to the judge. If you're ever in court, whether you're a lawyer or defendant, prosecutor, whatever, be nice to the judge. Indigent defendants. As we discussed a few sections ago, if you are indigent, which is the fancy legal speak for being poor, you can have a lawyer appointed to you for purposes of trial. Now, there are different ways that different states do this. In some states, they have a public defender's office, right? Which is basically there are lawyers that work for the city or the state or whatever, and their entire job is representing, free of charge, indigent defendants. In other states, basically every lawyer who's licensed to practice in that state puts their name in a pool. And every time an indigent defendant comes up, they kind of take the next person on the list, right? So if you're the next lawyer on their list, you get assigned this indigent defendant. Doesn't matter if you're like a tax lawyer who works for, ExxonMobil or something. You are required to do your duty as part of a lawyer of that state and defend this person accused of a crime free of charge. And that's kind of the price you pay and the service you give back in order to be a lawyer in that state. And then some states do slightly different versions of those two, but those two are the big ones. Those two are the kind of the most common ways to do it. Now, jury duty. I have a very long, rambling speech about jury duty. I'll try to keep it short. But the short version is, very often I hear people get very upset about when they see in the media the outcome of a trial or the outcome of a grand jury investigation or whatever. And every time I hear somebody get upset about this, I always ask them, well, what did you do with your last jury duty notice? And if they reply, oh, I got out of it, well, then shut up. If you want to complain about what juries decide, the solution to that, the alternative to that, is serving on jury duty yourself. This is a part of the price we pay for being American citizens. We vote, we serve on juries, you know, these are the things we do to ensure that the American process continues. So the next time you get a jury duty notice, don't throw it away. Don't try to get out of it. Show up, participate, be honest. And in fact, you should hope that you get put on a jury, because the jury has a lot of power. You should want to make sure that that power is used in a wise and productive way. Okay? So that's my speech about jury duty. But also think about this. You know, the Constitution guarantees you a right to trial by a jury of your peers. So what constitutes a peer? Does it have to be someone of the same age? Does it have to be someone of the same race? Does it have to be someone of the same education level? No. When the Constitution says a jury of your peers, they just mean a jury of your fellow citizens. Okay? And they could be a completely different race, they could be completely different gender, they could be a completely different income level and education level and all those things. And they're still your peers. This has caused problems historically when things like African Americans are put on trial for felonies and the court assigns a all-white jury. There is documented evidence that all-white juries are way more likely to convict the African Americans than they are to convict the Caucasians. So there is something to be said for ensuring that any given jury is diverse, both racially, gender-wise, income-wise, all those things. There is definitely documentable, quantifiable evidence that diverse juries are not nearly as they do not let race and gender and income and all those things impact their decisions nearly as much as the stratified one race, one gender, one income level juries do. Does that make sense? All right. That's the end of Section 9. Thank you guys so much for listening. I will be back with Section 10 shortly.